defense has a big dilemma on its hands because they essentially promised something to this jury in the beginning of the opening statements. And as an advocate, and I teach on this regularly, you want to be a source of credibility in that courtroom. When you say something is coming and you don't deliver, that certainly goes to the credibility of the defense case all along. So the defense is going to have to try to grasp at straws in the cross-examination points that they had throughout the witnesses. That's all they have. They did not call experts. He did not testify. And if I were a prosecutor, I'd be on my feet trying to keep those arguments out because they're not grounded in admissible evidence or testimony that the jury heard.
You're the Commonwealth prosecutor. What do you do, David, if he starts talking about what Brian said, thought, felt at that point in time?
I would stand up with a verbal objection. Judge, that is not in evidence. Now, advocates, they don't like really making a lot of arguments or objections during closing arguments. But with that being said, that's a big one for the prosecutor because that's during the defense closing, right? So you get an opportunity to stand up and make a legally grounded objection, which is also highlighting the fact that we never heard anything like that. And I would stay away from it from prosecutors in the sense that I'd be like, an opening statement is what you expect to present and what you expect to hear, and that's not evidence. And say it sort of objectively and not be point number one on the appellate brief commenting on defendant's constitutional right not to testify.
Right, David. Yeah, I couldn't agree with you more. Yes, I thought a lot about this because if you're a prosecutor, you want to let the jury know that, hey, this hasn't been admitted as evidence, but you can't do what's called burden shifting, where you're saying you never heard from Brian, what you can't comment on him not testifying. You never heard the defense present any evidence about this. You can't say those things if you're a prosecutor. So David's exactly right. You say something like, you heard, myself and opposing counsel get up and talk in opening statements. And remember, those first things we said are just opening statements. They're actually not facts in evidence. Those come from the witness stand, members of the jury, what you heard in the meat of this trial. So there you're being general, as David said, you're being objective, you're not going to create an appellate issue.